Well, I'm not going to start with a picture or a joke. Still, I'd like to start the presentation maybe a bit on a more personal note, which is how did the book come about on a personal level. So while I was doing the research for this book, my father was terminally ill. He passed away from cancer. My father was, like my mother, was the archetype of the scientist. In fact, in the last month of his life, what he left for my brother and me was a binder for each, a binder he had compiled with all his scientific publications. And he believed that the true hallmark of human intelligence is its adaptability, its capacity to solve problems under new circumstances. And I think that would be a pretty good advice for anti-doping these days. So to the presentation. At the time, I was working as an attorney, working on doping cases before the CAS, and I was also doing a program in life sciences. And it's at that time I really started reflecting on the role of science in a legal context, whether it's in rule drafting or in judicial decision making. And that formed the basis for the book, which I'm going to try and summarize in the presentation today. To keep the premises of the title, we are going to start from Meldonium. I'm going to explain what that is. To elaborate on some of the deeper issues that actually Meldonium simply brought to the public attention, to the attention of the media and of the general public. We'll come back to Meldonium throughout the presentation, but for the structure I'd like to consider the pair in the subtitle, which is scientific complexity versus legal fairness. My point is that science and law are two disciplines that operate with different goals, with different requirements, and with different methodologies. So if you don't invest efforts in understanding each other, you risk up ending with a system that is neither scientifically solid nor legally fair. So I would like to start from the general and then gradually move to the particular. Please forgive me if I have to pass very quickly on this over certain aspects or skip certain aspects. We can come back to these during the discussion. We only have a bit more than 1 hour, which is already enough to put you all to sleep, but certainly not enough to tackle all the issues that were in the book. So in the first part, I'd like to see how to build a system of legal prohibition in a science-based area like anti-doping. Then in the second part, how is proof on scientific issues regulated within that legal regime, the anti-doping regime. And finally, how to make use of scientific evidence within particular doping disputes. So if we start with the first part, I'd first like to emphasize WADA's job is a difficult one on this point. So I'm not going to deny that. I'm not going to take a purely accusatory position. The fact is the code, the World Anti-Doping Code, is a science-based law. In that most topic it has to regulate, have medical, sports physiological, or at least chemical components. But the code also involves restrictions on the athlete's rights and freedoms, regulating what substances an athlete is allowed to put into his or her body is a restriction. Withdrawing biological fluids, urine or blood from the athlete is. Banning an athlete from exercising a professional activity is. So if we want to set up law in a scientific context, we need to have scientific foundations to justify the restrictions and then apply those in a proportionate manner. I was rather surprised, or positively surprised, to find this statement in a document that has just been published by the WADA ethics panel on the guiding values of anti-doping. Any decision, recommendation, or policy should be based on the best available scientific evidence. There are three components within that statement I would like you to keep in mind for the first part of the presentation. Best available. So what do we do if there is no way to obtain the evidence? And the second should be what is the reality of the inclusion process there? And finally, based on how far can science really give us the basis for a legal regime, and where does simply pure legal policy start? On that subject, anti-doping seems to be going through a form of identity crisis at the moment. That became quite obvious when Meldonium appeared in the landscape. This is a statement that was made in that context by Russian athlete Tatiana Firova. A normal person, she said, that was reported in the press, a normal person can take banned substances if they want to, so why can't athletes take them as well? How else can we achieve high results? So that leads over to the Meldonium debate. What is Meldonium? Well, to sum it up, it's a drug marketed as a pharmaceutical product that is supposed to increase blood vessels so that it improves blood flows and protects organs, in particular the heart. So what happened with Meldonium? In reality, what surprised me is that this is very much a textbook process according to the WADA process. There was abuse suspected of Meldonium. Accordingly, Meldonium was added to the 2015 monitoring program of WADA. During the monitoring program, studies shown that there was a surprisingly high prevalence of use of the substance, coupled with an absence of mention on the doping control form in many cases. The idea of banning the substance was approved by the WADA Health, Medical and Research Committee in September 2015 and then approved by the WADA Executive Committee. The modification was announced on the 1st October 2015, which is according to WADA rules that in ordinary circumstances, a newly prohibited substance or a change to the list is announced at a minimum 3 months before the change becomes effective. And the new list, the 2016 list, becomes effective on 1st January 2016. And then that is where things seem to get a bit out of control. From January to March, the cases start to accumulate. In early March, there was the announcement by Maria Sharapova, the famous tennis player, that she tested positive to Meldonium with reactions from her sponsors. And in April, WADA issues a first notice on Meldonium. The first notice allowed for certain results management procedures to be stayed, for provisional suspensions to be lifted in certain circumstances, and announced that additional studies on excretion times were contemplated or were going to be conducted, and that certain concentrations in certain cases may be regarded as a no-fault or negligence case for the athlete. Thereupon, various actions were taken depending on the anti-doping organizations. The ITF tribunal rendered its decision in the Maria Sharapova case. She received a 2-year sanction, so no 4-year sanction, but she appealed the decision before CAS in order to obtain a reduced sanction for no significant fault or negligence. No one else, neither WADA nor the ITF, decided to appeal the decision. And then very recently, on June 30th, WADA issues a second notice on Meldonium, announcing the results of some additional excretion studies, and the notice also contains some further recommendation on results management and consequences. One question you could ask yourself is, what is there so special about the Meldonium? Well, there are a number of factors, I think. First, the number of cases was rather unprecedented. Then the timing. Meldonium came amidst a confidence crisis, related to Russia and the pre-Rio Games. So it came at a time of, I'd say, over-excitability of the public opinion. And it was a substance that was legally marketed in Eastern countries only, so it was clear that athletes, especially from Russia or Eastern European countries, would be predominant in the positive test. Then, of course, there was the high-profile case of Maria Sharapova that was highly mediatized. And, well, finally, doing good communication on issues that are both legal and scientific in the background is a really tough task. So the reactions in the media were really strong and not always straightforward. It was said that athletes were going to be acquitted. The question was why exclusion studies were announced only now, whether results management had been stopped or stayed. So there was a lot of ambiguity around in the public. And two types of issues especially were debated. The first was about the communication for the modification of the list and how warnings had been issued with respect to Meldonium. And the other one was about the merits, the contents, should Meldonium be on the prohibited list altogether. For this hour, I'm going to focus only on the second aspect. We can probably discuss the other aspect during the discussion if you wish. So should Meldonium be on the prohibited list? That's a really fundamental question. One could, in particular, read and hear in the media that there is no real proof that it enhances performances. And it's true that substances prohibited by the WADA code are often referred to in lay terms as PEDs, so performance-enhancing drugs. But what is really the mechanism used in the code to include those substances? That is Article 4 of the code that lists 3 criteria to take into account. Potential for performance enhancement is only one of them, along with risk for the athlete's health and violation of the spirit of sport. And as to their interplay, 2 out of the 3 need to be met in order to be considered for inclusion. So proof or even the claim that a substance is performance enhancing is not needed under the code. And of course, what we are interested now herein is what is exactly the role of science in that inclusion process. Looking at Article 4 still, you can see that the code does require medical or other scientific evidence, pharmacological effect, or experience. We could discuss the interpretation of these terms, but still, we see that this contemplates some assessment rooted in specialized expertise of some sort. And in the WADA process, this expertise is brought by the list expert group, which then reports to the Health, Medical and Research Committee, which make recommendations, and the final decision is made by the WADA Executive Committee. On the other hand, the same Article 4 adds, in the 2015 code, WADA in its sole discretion determines, etc. So we have this ambiguity already between requesting scientific evidence and the sole discretion of WADA. The reality is the mission of the list expert group is a kind of a headache. If we start with remember our limb, the best available evidence, how do we actually gather the evidence on the effects of a substance or a method? The ideal solution is you do the equivalent of what is being done in clinical trials. You know that prohibited substances are often at their origin pharmaceutical drugs. So you do a control study against placebo on elite athletes and in conditions as close to reality as possible. So that's the ideal solution. And it's rarely done in practice for various reasons. In particular, research ethics reasons are invoked. We could address that in the questions too afterwards. So in many instances, the list group will actually rely on second-hand evidence. If it's a therapeutic product, it will maybe extrapolate from studies conducted in patients to the effects that it could have on a healthy athlete population. And that was in particular what happened also with Meldonium. There were studies available on populations that had a medical condition. Otherwise, sometimes we have to deal with clinicians' experience or even observe the evolution of results over time when we know a substance is emerged or is being used in an athlete population. Or, and here we come back to Meldonium, WADA says in the explanatory note on the 2016 list, Meldonium, maldonate, that's the other name, but I won't discuss this issue in this hour now, was added because of evidence of its use by athletes with the intention of enhancing performance. So now you're going to say, well, wait a minute, is used with the intention to enhance performance to be equaled with the scientifically supported potential to enhance performance? We can discuss that afterwards too. I'm sure there will be questions about that. My guess is that in reality the two criteria that were used here were rather health risk and violation of the spirit of sport. But the other question is, does it matter? As matters stand, there is no requirement for WADA to state the pair of criteria based on which a substance or method is included on the list, nor to disclose the supporting scientific background that was used for the inclusion. And as matters stands, there is no possibility to challenge in a particular matter the inclusion or the status of a substance on the list. And there is an explicit exclusion of judicial challenge in Article 4 of the Code. And that was one of the key issues discussed during the 2015 revision process. Initially, the first draft version contemplated that performance enhancement would become a mandatory criterion, which would then have to be paired with either of the two other criteria. One of the key concerns expressed by the scientists at the time was that this would paralyze the list expert group, so it would force them to back each time the decision with evidence of performance enhancement, and that was something that would make the system completely unworkable. And what was at the time the discussion at the WADA Executive Committee? I'm going to read it out for you. The team had tried to address his concern, the concerns that I just mentioned, from a legal point of view, which was that the criterion for whether something was a prohibited substance or not was not studies. It was if the list committee determined in its sole discretion that the substance or method alone or in combination had the potential to enhance performance. Now the important part, scientific proof had been taken out. That might be awkward for the scientist. I'd say it might be awkward for some lawyers too. And finally the proposal was dropped, and we're still living under the same 2 out of 3 rule with no predominant importance given to performance enhancement. But that shows you another aspect of the power of legal regulation. Generally, it's much easier to try and remove the requirement for evidence than to try and collect that evidence. So we have seen the difficulties in gathering available evidence. Now remains the claim that the policy be based on science. And that is where I would like to come to the limits of what science can do for you when you are trying to build a legal regime. Everyone, well, most people anyway, feel that there is something inherently wrong about doping. But if you ask exactly why it's wrong and what exactly should be considered doping, then you find that moral judgment and values play a much more important part than science. And in fact, there is one current of opinion that feels that anti-doping should focus on what is really detrimental to competitive sports, so what endangers the level playing field, and the other opinion that views doping more as a public health issue. The important aspect here is that science cannot provide moral choices to guide legal policy. And during the review process, one of the most debated issues was the use of recreational drugs, in particular cannabis. I had an example on cannabis, but maybe we can come back to that during the discussion. It was one of the important issues that led to performance enhancement not being made a mandatory criterion, and it also led to some technical changes on the status of cannabis, but cannabis remained on the prohibited list. There is another example I'd like to show you on that point to close this part. This is a chart taken from an article that was recently published and that I co-authored with Marcel Sougy and Sylvain Giraud from the Lausanne lab. I call that a trolley problem by reference to those studies, those studies in which you try to identify moral choices based on what people would sacrifice if they had to make a choice about who to get crushed under a trolley. Defining threshold for substances that can also be endogenously produced or produced by the human body, for example, human growth hormone, has become a central aspect of anti-doping science. And in this article, we were explaining what the different limits, in the sense of mathematical figures, apply in analytical science and what legal implications these limits are. So I don't want to go into the details, but this shows you what data science can provide you with as a basis for setting a threshold value and what it cannot provide you with. The curve shows you the percentage of the population that naturally has a certain concentration of the substance. Do I have a pointer? So here you see the point at which the 95% of the population would fall below the threshold, and this point, the point at which 99.9% of the population would be below the threshold. The important point is, the important point is the curve is what you call an asymptote, so it never gets down to zero. So all the science can give you is this curve. It cannot give you where to draw the line. And that is where policy steps in. The choice as to what percentage of the population considered, whether it's 95% or 99%, should lie above the threshold, respectively, what remaining percentage should be accepted above the threshold is a policy-making one. At some point, regulatory bodies must make a decision what risk the anti-doping system is willing to tolerate, that a small percentage of athletes that have naturally elevated levels will be reported as positive, as a compensation for avoiding that athletes with naturally low levels can then dope without getting caught. And that is not a question that science can answer for you. So to sum up for the first part of the presentation, the current system, unlike what is often thought, it does not rely exclusively on performance enhancement. In fact, in many instances, the hard scientific data for performance enhancement is weak and rather scarce. Second, there are many reasons that may lead to decisions with respect to the contents of the list. Many of them are not necessarily linked to scientific considerations, so policy may trump science in certain cases. And finally, there are limits to the legitimacy science can give to a legal regime. As I said before, science cannot provide moral choices to guide legal policy. It can only provide you data to assist you in your decision. And also an important point is, it can only assist you in concretizing your legal goals if you are aware and coherent about your policy choices. So the definition of the prohibition is not the only scientific issue that has an influence on the harshness of the regime for athletes. What I would like to address next is something that tends to get disregarded, but that is really crucial to the fairness of any legal system, and that is the regime of proof. Proof on scientific issues, one of the most recurrent themes in doping disputes, and the topics that most frequently turn up in the proceedings are the validity of the analytical tools that are underlying positive samples. Some may remember the series of cases that were dealing with human growth hormone in recent years. Another very frequent topic, procedural flaws during testing or during sample analysis and their impact on the outcome of the analysis. And finally, the causes for the analytical finding. What was at the origin of the positive sample, or for the athlete biological passport, how to explain an abnormal passport profile. So what is the rule of proof here? What we need to remember is that the mechanics of science are different from the mechanics of law. There is no supreme authority to decide once and for all what is scientifically correct. And the state of knowledge is continuously evolving. So science is in progress, but by contrast, the judge at some point must make a decision on the dispute. And for this, the judge has received a legal instrument of the burden of proof. The burden of proof, to simplify, tells you which party is to carry the risk that the judge at the end of the proceedings is not able to form an opinion to the required standard of proof on an issue of fact that is disputed. So it's a solution for a lingering uncertainty on the facts. And this means for scientific issues, this means that the party who has the burden of proof has the burden of scientific uncertainty. Now, when an issue is scientific in nature and it is disputed in a legal procedure, usually it means that matters are not precisely settled within the scientific community, or that issues have not been sufficiently explored to allow for final scientific conclusions. And for this reason, when the judge or the hearing panel allocates the burden of proof to a party, that pretty much in reality amounts to predetermining the outcome of the dispute. And this is the case in anti-doping, just like in other science-related domains that require regulation in sports. I'm going to give you an example outside anti-doping. You may remember the case of Oscar Pistorius. Pistorius was a double amputee and a track runner who used the now famous cheetah prosthesis, and he claimed the right to compete in IAAF events with able-bodied athletes. The IAAF refused to accept his participation based on a rule that had been newly introduced that was prohibiting use of technical devices, giving the athlete an advantage over other competitors. The matter was brought before CAS. It was accepted that the burden of proof was on the IAAF, and Pistorius underwent a series of performance studies which turned out to be inconclusive. So the CAS panel found that there was no sufficient scientific evidence produced to show that Pistorius had an overall advantage over able-bodied competitors. So the CAS granted him the right to compete at IAAF-sanctioned events. Now this year, the German long jumper Markus Rehm wanted to compete at the Rio Olympics, well, either the Paralympics and or the Olympics. He's a long jumper and a single leg amputee who used the same type of prosthesis, and he claimed the right to compete at the Olympics with able-bodied competitors. Studies were conducted at the Sports University in Cologne, and the report was very recently published. And the conclusion of the study is, at this point, it's not possible to tell with certainty whether Markus Rehm has an overall advantage or not in long jumping based on his prosthesis. Study inconclusive. So, same outcome? Well, it seems not. There has been no true decision, but it was just announced some days ago, as was already anticipated at the IAAF June meeting, that Rehm will not compete in Rio. because he has not shown that the prosthetic doesn't give him an unfair advantage, as Sebastian Coe said. So what happened in the meantime? Well, what happened in the meantime is this. This is a rule that was introduced between the two cases in the IAAF regulations that tells you, among others, is prohibited the use of any mechanical aid unless the athlete can establish on the balance of probabilities that the use of an aid will not provide him with an overall competitive advantage, etc. Unless the athlete can establish. So you see what happened. The burden of proof and thus the burden of scientific uncertainty has been shifted onto the athlete. And from now on, if the science is inconclusive, the athlete suffers the disadvantage, no longer the IAAF. By the way, they announced they're going to set up a working group that is going to explore how to allow disabled athletes to compete at the Olympics, so the door remains open to changes. But this is a wonderful example to show you the mechanics and how the burden of proof can be used to exploit scientific uncertainty to the benefit of one of the parties. I could do exactly the same example for the duty charm case you may have heard of about the hyperandrogenism regulations. We can discuss also the example in the questions if you wish. Let's get back to anti-doping. What about anti-doping? Well, the code places the burden of proof on the athlete for important scientific issues. The three most important ones are the validity of the analytical tools, which was mostly a reaction to those human growth hormone cases I mentioned before, in particular the Verpalou award, showing that procedural defects occur during testing or sample analysis, and very importantly, all aspects related to fall, which in terms of evidence, that means showing the origin of the prohibited substance, how it ended up in the sample. I don't know if the topics sound familiar to you, but it's those I mentioned earlier as the key scientific issues that turn up in doping disputes. So the code really makes an effective use of the burden of proof to facilitate the evidentiary efforts on the anti-doping organizations. For today, we are going to focus on the third aspect, on the fault aspects, because I think it's the one that's most relevant to the changes in the 2015 code, in particular with the introduction of the intentional doping provision. But let us get back to Meldonium first. On 30th June, there was a second notice. There were first results published about the additional excretion studies. And, well, an excretion study is when you administer the substance according to a protocol to a certain number of subjects, and then you measure the excretion patterns at different time intervals in the fluid, for example, urine, that you are going to use for the detection. And there would be lots to say about the notice, but I would like to look just at the footnote that was inserted at the end of the notice. As a matter of course, for reasons of efficiency, WADA does not conduct excretion studies before including a substance on the prohibited list. This information is generally provided by the manufacturer. In the case of Meldonium, no information was provided as it relates to urinary excretion. For reasons of efficiency. And the question is, efficiency for whom? And there we need to explore a little bit the pillars of doping control. What I call the proof in a bottle system. Traditionally, doping control focuses very much on what we call the adverse analytical finding. It's the detection by a lab of a prohibited substance or evidence of a prohibited method in a sample. And it was determined at some point that this is enough indication that the athlete did something wrong and that it was the responsibility of the athlete that this happened. From the moment an adverse analytical finding is reported, the burden shifts to the athlete to explain what happened. This is a chart that shows you the basics of the sanctioning regime under the 2015 code. You see the main division here is between non-specified and specified substances. We can come back to the details if you're interested. What I would like you to look at for now is there is only one constellation in which the anti-doping organization has any burden of proof, and that is for establishing intentional doping in case of specified substances. Meldonium is non-specified, so we are not concerned here with that constellation. For all other aspects, to reduce the sanction below 4 years, the code systematically places the burden of proof on the athlete for all 4 aspects. And if the violation is based on a prohibited substance in the samples, this supposes showing how the prohibited substance entered his or her system. That's the wording of the definition in the code. In other words, you need to find the origin of the substance, the causes behind the adverse analytical finding. And here's an example, not of meldonium, but of cocaine. Cocaine is a non-threshold substance, so all that needs to be shown in theory is the identification of the substance in the sample. No threshold, no quantification, etc. But the causes behind that adverse analytical finding, they can range from actually deliberately using the substance for performance enhancement. I don't know whether that is possible with cocaine, but it has been submitted that it is, to a completely unavoidable contamination. And you can see those causes reflect very different levels of fault. Actually, Richard Gasquet, the tennis man again, and his famous French kiss defense, he was granted a finding of no fault or negligence at the time by the CAS. So you have one and the same positive sample, produced as a support by the prosecution, if you want, a variety of causes behind the findings, and a range of sanction that can be from 0 to 4 years in case of intentional doping. And that is where currently the use of scientific evidence, as was originally imagined by the code drafter, is becoming inadapted. The reality is that today, if you want to adjudicate cases, you need to be able to frame what is called in forensics as hypotheses or propositions. And the closest in CAS parlance would be scenarios, doping scenarios. So, of course, the next question is, how do you find out about those causes? And that is where scientific evidence, in particular analytical data that you can gain from the sample, can have huge value. And that is one positive feature of the Meldonium affairs I would like to highlight. It compelled WADA to commission studies that would actually assist the athlete in establishing no or low fault. Because ultimately that is the stake of the studies. You are going to determine the possible timing of last use in order to get indication on the level of fault. Is the fault simply not anticipating that the substance will still be present in the body after 1st January, or is it continuing to use the substance after 1st January, so after the effective date of the prohibition? And there has been a lot of criticism that WADA should have conducted those studies before banning the substance. That may be a valid point, but it misses the fact that the current regime was so far not very concerned by the causes that led to the analytical findings. So it's actually a step forward. And why was that? Because the burden is on the athlete to explain the origin of the substance in the positive sample. So I do think that anti-doping organizations should become more proactive in assisting athletes in discharging their burden when scientific evidence is at stake. And that is true both for the access to expertise, we'll come back to that in the third and final part, and for the access to the raw materials, which is the sample and any information that you can derive from the sample. On that point, Maria Sharapova was able to obtain in the proceedings before the ITF tribunal even the results of other samples, those that had been collected from her at the time Meldonium was still only on the monitoring program. It's the first time I saw that in a decision. Again, to sum it up, we have seen just how the code manages to standardize the evidence. The anti-doping organization only has to produce an adverse analytical finding showing the presence of the substance to trigger the shift in the burden of proof. So historically, it was thought that the origin of the substance was within the athlete's sphere of control. So the athlete ought to know what happened, and it was in a much better position to explain what happened than the anti-doping organization. And this position was or is respectable. But today, as we will see in the last section, this is no longer necessarily true. And that leads us to my last topic: how do we best make use of scientific evidence in doping disputes? By scientific evidence, I mean, first of all, expert evidence. Most scientific evidence that is presented in doping disputes is expert evidence of some sort. In fact, the only true raw scientific evidence in a doping case would be the sample itself. But to my knowledge, the sample itself is not typically produced as such in the proceedings. Instead, what lawyers get is a lab report, more lab reports, expert reports on the reports, etc. And those are all expert observations, either of reality we cannot see with our own eyes, what was in the sample, expert explanation on general scientific background, does this substance have the potential to enhance performance, or expert opinions on the facts of the case. Is it credible that the athlete took Meldonium only before the effective date of 1st January 2016. And the first issue that deserves the attention of the anti-doping movement, in my view, is a structural one. And that is, where do we get our experts from? I call it the independence versus competence dilemma, because people these days tend to insist on the importance of independence, but I think it really needs to be a balance between independence and competence, proficiency. This dilemma, you find it in every field in which experts are called upon, because the more proficient a person is in his or her field, the more he or she is likely to have ties within the field and to have pre-formed views on a subject. But there is an additional aspect that is more specific to the anti-doping, and that is the fact that the system of WADA regulation has created a form of institutional scientific community, with the most evident illustration being the network of WADA accredited labs. Those labs have the highest specialized expertise, probably one of the highest in the world, but they operate according to WADA technical rules, and they provide analytical services to the anti-doping organization. And it's not totally clear at this point to what extent labs are bound by the WADA codes of ethics and or are encouraged to intervene only upon the request of anti-doping organizations as experts. In practice, just looking at CAS awards, it's pretty simple. It's clear that lab experts within laboratories systematically appear as experts appointed by anti-doping organizations. And this has detrimental effects for establishing the truth. First, because it restricts the best expertise to one category of parties. And the second, perhaps even worse, is it pushes the other party, the athletes, into the arms of experts who, let's say, may apply less stringent standards of ethics. When I'm saying that as a matter of experience, when I was working as counsel in front of CAS, we were confronted repeatedly with expert statements that were true advocate submissions, saying this decision is completely arbitrary, and I'm going to show you why, basically, in the expert report. So, and that damages procedural efficiency, and in the end, it damages the cause of the athlete. So, how to solve that dilemma? First, a first solution is to encourage hearing panels, I'm thinking of CAS panels here, to appoint their experts rather than to rely only systematically on party experts. More importantly, perhaps, is to really make it clear that experts within the anti-doping movement are free to intervene to the best of their scientific knowledge for any party, even on behalf of athletes, and even to question the results of a low lab, if needs be. It has been put forward in the past that this could be against the WADA ethics code for laboratories, since it could lead a lab expert to undermine the anti-doping program. I think preventing questionable analytical findings from leading to sanctioning an athlete cannot never amount to undermining the anti-doping program. It's the contrary. Knowing that there is a process of peer review in place is the symbol, is the science, the pillar of a solid anti-doping science and of a fair handling of analytical cases. And finally, on the procedural aspects, there are various tools to manage expert evidence more efficiently, such as pre-hearing expert conferences with statements of agreement on certain issues. If you're interested, we can discuss that in the questions too. Beyond the quality of the expert, another important issue is the growing importance of expert interpretation of the results. Why is that? I give you a comparison between a typical historical doping case as it was contemplated when the code was designed and the case today. The code was designed for xenobiotics, means basically chemicals that are purely exogenous, that cannot be produced by the human body. Taken in big doses before or in competition periods, and easy to identify with qualitative methods of analysis. I mean, you have heard about gas chromatography, mass spectrometry. I did it. And the typical example was amphetamines. Today, what we are dealing with are substances that mimic substances naturally produced by the human body. For example, recombinant human growth hormone, with elaborate doping protocols that often target periods between competition periods. We've seen that, for example, with the EPO microdoses. And these put much higher requirements on the analytical methods, but perhaps more importantly on the expert interpretation of the results. So in the initial design of the code, again, the situation was rather straightforward. An anti-doping organization would perform testing on an athlete, the lab would report the results. We would be in that binary position in which either the lab would report an adverse analytical finding, presence of the substance, in which case there was a violation, or not, in which case there was no violation. From this point on, as we saw, all further steps are for the athlete to take to clarify the origins of the findings. The reality we are dealing with is quite different. We still have the adverse analytical finding, but we also have a variety of other preliminary, intermediate analytical findings that are not that clear-cut or call for further investigation. Presumptive adverse analytical finding, to give you an example, is for substances like glucocorticoids that are only prohibited through certain routes of administration. Decision limits in the test that try to discriminate endogenous from exogenous origin of a compound. Reporting levels to avoid irrelevant trace levels in substances that are prohibited in competition only. So, to clarify, I'm not trying to criticize the power of analytical science. There is really great progress being done every day to keep up with these new doping patterns. But the trouble is that we remain stuck with a legal regime that was designed for a black or white, yes or no decision, and now we are dealing with all these different shades of gray. And that leads me to my last topic and the most difficult one, and now we are going to close the door so that no one can get out. It's the interaction between experts and legal hearing panels, and we are going to talk about probabilities. I'd like to proceed along 3 points. The first is scientific evidence is probabilistic. The second is the expert cannot replace the judge or the hearing panel in its role. And the third is that there is a huge potential in anti-doping to enhance the handling of scientific evidence. Probability are often frowned upon by lawyers because there is a feeling that the judge, when the judge is establishing the facts, he or she speaks the truth. And that's even more so for scientific evidence, because scientific evidence is typically considered the supreme rational evidence. But the reality is it's always probabilistic. So I have here and this is known in the contents of forensics. I have here a quote from a Neuchâtel University colleague who wrote her thesis on DNA, who says, it's in French, I'll read it out in English. The resistance some lawyers show against the use of probabilities to evaluate evidence is all the more bizarre, given that none of them would reject the idea that the judge must reason using logic, and probabilities are nothing but formalized logic. So the potential for errors when you are dealing with complex scientific evidence is much greater without a grasp of probabilities than trying to make an educated use of those probabilities. And in the forensic context, those issues are being debated. Anti-doping, in the end, is a form of forensic process. You try to determine, based on mostly scientific evidence, whether a prohibited conduct occurred. But unfortunately, those forensic tools have not really yet managed to pass the doorstep of the courts in this field. And until now, there was no real need for it because of this absolute character, yes or no character of the adverse analytical finding. When it's there, it's there. When it's not there, it's not there. But we need to get away from that perception and accept the sophisticated nature of the evidence. And understanding probabilities also gives you a view on the role of the expert compared to the role of the hearing panel. And it avoids that one steps into the role, the function, the ambit of the other. Let me try to explain. An expert provides information on one or more pieces of evidence that is provided to him. I'm going to drop the her for the sake of the demonstration because it's complicated enough without introducing the gender issue into the debate. So the expert gives you the value of the evidence considering various hypotheses. For example, the expert can give you the likelihood of observing a certain evidence, assuming the athlete was doping or not doping. The judge must form an opinion on the fact-finding and reach a decision on the issues at stake. So the judge is going to assess the likelihood that the athlete was doping based on all the evidence on the record. And why is that role are the roles separated in that way? It's because the expert only has at his or her disposal the pieces of evidence that they are asked to consider. It's only the judge can then integrate all the scientific and non-scientific evidence on the file and make a decision on fact-finding. And we distinguish, so you can see this can be distinguished in terms of symbol. P of E of H is the probability to observe the evidence assuming a hypothesis. Usually you need in forensics two alternative hypotheses. To simplify, we could say doping or non-doping in our context. And the legal hearing panel needs to assess the probability of a hypothesis being true, given all the evidence on the record, including maybe the athlete's statement and other than scientific evidence. And I would really like to stress, I may sound like complicated things, but the detection tools in anti-doping have become very sophisticated. And we'll see in a couple of minutes, we'll finish with the athlete biological passport. I love the athlete biological passport, but there is a price to sophisticated scientific evidence. At some point as a hearing panel, you cannot just rely on your common sense anymore to evaluate the evidence. And why? That's because probabilities are extremely counterintuitive. I'd like to show you just a short example of that. Inversion fallacy is a very famous type of fallacy known especially in jury trials in the US in criminal law cases. We'll try to simplify again and assume there are only two hypotheses: the athlete was doping, the athlete was not doping. So you get back a result from a test from the lab. The test is positive. The experts tell you the test has a false positive rate of 1 to 10,000. Now my question is, what is the probability that the athlete doped? Does anyone have can someone throw a number? No number, no one dares to throw a number. Well, in many cases, people would say, well, it's 9,999 out of 10,000, 1 minus the false positive rate. And this is very well known in America, it's known the prosecutor's fallacy. It amounts to reversing the direction of the probabilities I showed you earlier. It substitutes the probability of the cause to the probability of observing the effects. And why is it wrong? Here you can see it. Well, I can give you at least two reasons. We're not going to try to mathematically demonstrate that, but first, it takes into account only one test done independently. It does not take into account the impact of multiple testing. If you conduct 300,000 tests a year, like it's roughly the case in anti-doping worldwide, already you have 30 false positives in a year, just by multiple testing. And second, it does not take into account the prevalence of doping in the athlete population you consider. And the lower the prevalence of doping is in the population you consider, the higher the probability that what you find is a false rather than a true positive. And I'm going to give you another example to help you understand that. Let's assume you have, again, a test with a specificity. Specificity is another term to simplify to talk about the rate of false positives. Sensitivity, it's the reverse factor, the ability of the test to detect a positive when it is a positive. Prevalence of doping, we'll assume 1 per mil. I know it's low, but we'll assume that for the sake of the demonstration. You conduct 100,000 tests. You can do the calculus, I think it's right. You will get as many true positives as you will get false positive, 10 in each case. So in this case, producing a positive result means there is a 50% likelihood that the athlete was doping, and not, as we initially assumed, and which was very convincing for the prosecution, 9,999 out of 10,000 chances that the athlete was doping. And I'll give you as a final illustration, and then I release you from the world of probabilities. I'll give you the example of the athlete biological passport, because it's really the best example of the complexity of scientific evidence that legal hearing panels will have to deal with already on a daily basis. The athlete biological passport, it's often been described as a paradigm shift because it centers on profiles. So it monitors biological parameters of the athlete over time. And it's centered on the effects of a substance on the physiology of the athlete rather than on detecting a substance in a sample. The second thing is it tries to determine individual rather than population-based reference ranges. Those are the reference ranges. Those are the values of the different tests obtained from the athlete. And if here you have a non-atypical profile, if it were abnormal, the blue line would cross the red line at some point, to simplify. There are currently 2 modules, one in blood, one in urine. We're going to focus on the one that is most discussed, which is the blood passport, and the most ancient one, historically. So the athlete biological passport, it's a really nice scientific tool. It works based on what is called a Bayesian approach. It's a system that allows you to constantly update your degree of belief in a hypothesis each time a new piece of evidence is added. Here, a new piece of evidence is each time a new test, a new blood analysis. So how does the procedure for the athlete biological passport work? First, the system, the adaptive model it's called, it's basically a computer program. It gives alerts, so-called flags, when there are abnormalities in the profile, like I showed you before, when one of the blue lines here crosses the athlete's individual reference range. So it flags when the value would be found in less than 1 in 100 healthy and non-doping athletes. Then the passport goes into an expert review. So there is already an expert review at this stage, before even the proceedings are initiated, and the experts are trying to assess the causes for the abnormalities. And they do that based on 3 hypotheses on which the passport relies. The athlete has a normal physiology, is healthy. The athlete has a pathology, some sort of medical condition. And third, what is actually of interest, the athlete is doping, of interest for anti-doping purposes, to be clear. And then the legal hearing panel has to make the actual legal fact-finding decision, which is the likelihood that the athlete used a prohibited substance or method, sometimes referred to as blood doping in that context. The challenges, of course, you can see the challenges are high. On the side of the experts, they need to be able to apply those forensic approaches to assess the causes of abnormalities. And on the side of the legal hearing panels, they need to understand the bias and logic behind the athlete biological passport system. And to show you that these concerns about probabilities are not purely academic, and that the risk of fallacy is not purely theoretical, I'd like to refer you to that matter. I need to stress that the point was made in the decision obiter dictum, so it was not needed for this decision because in that particular matter, it was a special case in which the adaptive model had not actually flagged the profile. So the athlete was acquitted anyway, nothing bad happened to him. He was a cyclist. But the hearing panel made a comparison in the reasoning with what it would have ruled if there had been a flag. And that is where it gets interesting. So the panel says the athlete biological passport as such cannot be considered a proof that the athlete used a prohibited substance, as would be the case if a baseline value in the athlete's ABP was exceeded. That refers to the absence of flag. Indeed, in the later case, so if there had been a flag, it would be possible to use the aforesaid assumption that the likelihood of violation of an anti-doping rule by the athlete is 99.9. Now it's 99 in WADA guidelines, and thus so high that this fact can be considered proven to the committee's comfortable satisfaction. So at this point, you do not shriek out in horror. I'm going to try and explain why you should. The Czech panel takes the likelihood expressed by the flag in the adaptive model, and they directly conclude that this would amount to the likelihood that a violation was committed. Now, this is a double misunderstanding. There is a misunderstanding on the target of the probability that the adaptive model flags, and it's coupled with the error on the direction I mentioned before of the probability. The adaptive model refers to the targets the hypothesis of a clean and healthy athlete. But what the hearing panel needs to look for is the hypothesis that the athlete was doping. And the second, it gives the probability in the opposite direction, like an expert would. It gives the likelihood of observing that profile, assuming the athlete is clean and healthy, but the legal hearing panel needs to search for the likelihood that the athlete doped based on the profile value. So it's the opposite probability relationship. To simplify, the panel confuses effects and causes. And this is what happens if you put a highly, or what is at risk of happening if you put a highly sophisticated evidentiary tool into the hands of panels that are unfamiliar with forensics. And I said it was obiter dictum in that matter. But in fact, the WADA guidelines, the new WADA guidelines on results management suggest that in ABP cases, parties should make use of an option that is new in the 2015 code, and which is that the dispute should be brought directly before the CAS with the agreement of all parties. So after this little adventure into probabilities, I would like to conclude. I hope I have given you a view, even if it's a bit an impressionistic one, of the challenges that are involved in the scientific complexity of anti-doping. What I would like to take you into the discussion is, the first point is we need to gain clarity about the mission of anti-doping. Science cannot provide solid foundation if there is ambiguity on the goals we want to achieve. And we need to determine what we can reasonably aim for. There is the current slogan is protecting the clean athlete. And personally, I'm more and more inclined to skip the clean and simply protect the athlete. And this means viewing doping really as a health problem rather than a performance enhancement problem. And the problem with that is that it forces to treat doping as a health problem and to face the reality that elite sport is inherently not very healthy altogether. The second is the choices we make in the regime of proof are really decisive for the harshness of the system on scientific issues. Because scientific issues are difficult and costly to prove, and in many cases, as we saw, the burden of proof will need to serve as the fallback. And finally, scientific evidence is often considered as a supreme rational evidence, but that must not be confused with absolute. We saw that the evidence is probabilistic, and it requires lawyers to acquire a certain familiarity with uncertainty and with probabilities. And I know this is technical, but I think at least hearing panels need to be aware of these difficulties, because we have really good scientific tools, and refraining from using probabilities in the face of something like the athlete biological passport, it's like you were using hammer and nails to do quantum mechanics or something approaching. And I would like to leave you with one anecdote that summarizes well what I mean, I think. When we were working on that same article I mentioned before about the limits in anti-doping science, we were stuck on a paragraph. And that paragraph, I don't remember the exact paragraph, but it was about the fact that the lab needed to use in certain circumstances an internal standard. And we just didn't seem able to make sense of that paragraph. And at some point I realized we were probably just not talking about the same thing. And I said, well, what is your internal standard? Is that a document? Is that an object? What is it? And the lab person I was writing the articles with said, well, it's a fluid. It's something we put into the sample. It's physical. And at this point, suddenly everything seemed to make sense in the paragraph. And that is why we added that footnote in the article to make sure that everyone would understand what we meant. And we said, internal standard in this context does not refer to a legal standard, a norm internal to labs. It refers to a chemical product that is added to the samples before they are analyzed. And that may seem like a tiny issue, but I do think it's the only way of creating a system that makes sense. There are many instances of shortcomings or even just less than ideal situations that arise from a lack of understanding between lawyers and the scientists, and on what they mean and on what is essential to their disciplines in order to create a sound system. And I really think that is what I'm trying to work on currently. That's what I'd like to work on in the couple of next years upcoming. Maybe that will be the subject of the next book, and then we can all gather again and so on. On this note, I'd like to go over to the discussion.